Good morning. Welcome to an oral argument session here at the 5th District Court of Appeal. Marshall has introduced me. Let me tell you who else is on the panel today. To my right, coming from the Ninth Circuit, is Judge Jamie Grosshands. And then we're very pleased to have visiting with us this week on my left, Judge Michael Orfinger from right here in the 7th Circuit. At this time, if you've not already done so, please go ahead and turn off or silence your cell phones or any electronic devices so the arguments today are not interrupted. We do have 4 cases on the docket today. We're going to take a break, I believe, after the 3rd case, and there'll be a panel change for the last case on our docket today. Each side has 20 minutes for their argument this morning. The appellant can reserve as much of that for rebuttal as you would like. We've got a default setting of 5 minutes for the rebuttal. If you want more or less than that, that's fine. Just let me know when you come up. So this time, let's go ahead and start with the first case. Court calls Ronnie Batista versus State of Florida.
Good morning, Your Honors. May it please the Court, my name is William Pinnell. I represent Ronnie Batista, the appellant in this case. Please reserve 5 minutes of my time for rebuttal. Mr. Batista was deprived of a fair trial in this case based on the trial court's decision to deny 3 pretrial motions to suppress and based on his trial attorney's agreement to an erroneous instruction on self-defense. Based on our limited time, I'm going to focus on issues 1 and 4 of my briefs, but will certainly answer any questions from the court on issues 2 and 3. It's our position that the trial court erred by not suppressing all the statements Mr. Batista made to Darnell Adams, the police informant in this case. The trial court properly recognized that the police violated Mr. Batista's Sixth Amendment right to counsel, but imposed the wrong remedy. The court chose to suppress all the statements he made regarding the charged offense of first-degree murder, but chose not to suppress the statements he made regarding his purported attempt to hire Adams to kill 2 state witnesses. That remedy is not supported by the case law. It's actually contrary to the U.S. Supreme Court's decision in Maine versus Moulton and the 4th District's decision in Saunders versus State.
Counsel, can you tell us how you think, kind of going back to the original decision the judge made, how the police solicited or how did they get those statements? What do you think the police action was that tilted that toward them eliciting that information from your client? In this particular case, the law enforcement action is the trial court. The trial court initially found that the detective implicitly requested that Mr. Adams continue his conversations with the defendant over the phone, and the law enforcement set up a recording system, which allowed them to directly monitor the calls and record them. But did they direct what he was to say?
They did not, but they implicitly, the court found, and it's supported by the evidence, that they implicitly encouraged him to keep talking to Mr. Batista, and they'd already been told what Mr. Batista had allegedly approached Mr. Adams about, or what Mr. Batista's family had approached Mr. Adams about. So at that point, they knew, and it's undisputed on the record, that the detective knew that the right to counsel had attached, and they knew that they were deliberately going to have an individual talk to him and record him in violation of that right.
But had the right to counsel attached to the question of him hiring a hitman to kill 2 other people? Do you think his right of counsel attached to that issue too?
It had not, and what the cases say is that the statements under the Sixth Amendment, the statements would be admissible on a trial on that charge, but are not admissible on the charge that's pending before currently pending. So the violation of the Sixth Amendment right is, you're correct, is offense specific. So there's a violation as it regards to the pending charge, but not to the subsequent charge of solicitation to commit murder.
So what then are you suggesting was the purpose in the admission of those statements?
The state's purpose was to show consciousness of guilt. And the Saunders case in the 4th DCA said that was an improper basis to admit the testimony, and the error was harmful when the state introduced it for that purpose. And in this case,
And Saunders, though, one of the differences, there was active police participation in the Saunders interrogation, and here, arguably, it was much more passive. Wouldn't you agree? The level of police involvement in this case?
I'd say that I don't think that it's a little different because one of the officers is on the phone acting as
They
the
listened to
handler.
one call live, the other ones, they just listened sometime after the fact, right?
Well, one of the calls, yeah, one call live and one call after the fact, but they did design they did set up the system that recorded the calls and allowed them to monitor the calls. So it's not like they just sent the informant in there and said, see what he says. They set up a system to record the calls. They told him that they would see what they can do about his pending charges, where he was facing a maximum of 25 years in prison, and the
But he
trial
wasn't
judge in this
promised
case.
anything, and in Saunders, the informant was promised something, and that's
Well,
not different as well. Here, they said, we'll see what we can do. Isn't really a promise, is it?
Well, it's certainly some carrot. It's not we're not going to help you. It's some carrot, and the judge found that the detective knew that, and Mr. Adams testified the only reason he was doing this was to get a deal, and the detective knew that and took advantage of that fact to violate Mr. Batista's Sixth Amendment rights. The only difference in Saunders is that the officer was on the phone at some point as the handler. I'd suggest that's a distinction without a difference in this case.
Another big difference in Saunders, guilt was highly contested. In this case, your guy admitted that he was the shooter. A dozen witnesses saw him shoot. Isn't that a big difference as well?
No, Your Honor. He certainly admitted he was the shooter, but he claimed self-defense and defense of others. And his testimony was that he thought the victim had a firearm, was reaching for a firearm, and there was corroboration for that, for his testimony. Xavier Goitia said that multiple people in the other group in the altercation were reaching for their waistbands as they were coming towards his group. That's on page 471 of the trial transcript. He testified it seemed like they had guns. That's at page 472 of the trial transcript. Cruz Goitia testified that he thought the other people had weapons. Individuals in the roadway looked like they were reaching for a gun when he was arguing with RONNY Batista, and that individual acted like he had a gun. That's on 740 to 741. Detective Todd Monfort took a sworn statement from the informant, Darnell Adams, and he said that on a phone call with Mr. Batista, so this is a call between Batista and Darnell Adams, Batista told him that the dude was drawing a gun on him when he fired. So there was significant evidence that Mr. Batista acted in self-defense. You're correct that the issue of who the shooter was not disputed at trial, but the issue in question was, did he act in self-defense? And so it's our position that the erroneous admission of these statements was harmful because there was substantial evidence of self-defense and because the state's evidence was not overwhelming. The state argued vociferously for a first-degree murder conviction throughout closing argument. That was it. They argued there was premeditation, and even if there wasn't premeditation, it was clearly second-degree murder. The jury rejected that argument. Said it's not first-degree murder, it's not second-degree murder. They found it to be manslaughter. So there wasn't overwhelming evidence. They didn't accept the state's theory of prosecution. They went 2 steps lower. Had these statements not been admitted, there's certainly a real possibility that there would have been an acquittal. So the state cannot meet its burden to show that this was harmless error beyond a reasonable doubt.
Was there other evidence of consciousness of guilt that the state argued?
I guess they certainly argued that Mr. Batista fled the jurisdiction. Again, it's a high standard to show harmless error, proof beyond a reasonable doubt. I think it'd be difficult to say that testimony or statements, recorded statements that were played for the jury about the defendant trying to hire hitmen to kill 2 state witnesses would be harmless under these circumstances. And the statements were discussed repeatedly during closing arguments, 6 separate times. The statements were discussed during closing and referenced. So it wasn't a passing reference, it wasn't a single time. 6 times the prosecutor harped on this idea that there was this plan to eliminate witnesses. It's impossible based on that record to conclude that the improper admission of the statements was harmless. Additionally, we believe that Mr. Batista's conviction should be reversed because he was provided ineffective assistance of counsel when his trial attorney affirmatively agreed to an inappropriate instruction on the forcible felony exception to self-defense. This court has held that ineffective assistance of trial counsel may be considered on direct appeal if the ineffectiveness is apparent on the face of the record, and it would be a waste of judicial resources to require the claim be resolved by the trial court. And that's this court's decision in Morgan from 2014. Here, the jury was given the standard instruction on justifiable use of deadly force and was told that Mr. Batista was justified if he had a reasonable belief that the force was necessary to prevent imminent death to himself or another, or the imminent commission of aggravated assault against him or another. But then the jury was improperly told that the use of deadly force is not justified if you find that Ronnie Batista was attempting to committing, or escaping after the commission of an aggravated assault. And it's clear from the record that trial counsel agreed to that. We're not arguing otherwise. We're arguing that trial counsel was ineffective and that the agreement to that instruction was deficient performance in light of the fact that the Florida Supreme Court in Martinez in 2008 and this court in Sloss in 2010 had held that under similar circumstances this instruction was improper. So this trial occurred years after those cases. There was no basis or strategy decision for the trial lawyer to ignore those cases, to agree to that instruction under the facts of this case. And what those cases say is that unless the defendant is charged with an independent forcible felony for which he is not claiming self-defense, the forcible felony exception instruction should not be provided. Here, the sole charge before the jury was first-degree murder, and Mr. Batista was arguing self-defense. And it was his sole defense. Sole defense to the charge offense was that he was acting in self-defense. So there was no conceivable reason for trial counsel to agree to that instruction under the circumstances of this case. So it's our position that the deficient performance is clear from the face of the record in light of the Sloss decision and the Martinez decision. It's also our position that the prejudice is clear from the face of the record. Under the Spicer case from this court, the prejudice, a defendant need not show that counsel's deficient conduct more likely than not altered the outcome in the case. He must show a reasonable probability. So it doesn't have to be more likely than not. It doesn't even have to be 50%. It just has to be something that calls confidence of the outcome of the trial into question. Here, it's impossible, based on the circumstances in this case, for this court to have confidence in the outcome, given the fact that this instruction was given. The Florida Supreme Court and this court have said that this instruction is essentially an instruction that directs the jury to reach a judgment of acquittal or a directed verdict against self-defense, because it precludes them from using it if they find he was engaged in an assault. Again, self-defense and defense of others was Mr. Batista's sole defense in this case. His testimony about believing that the alleged victim had a firearm was corroborated by three other witnesses. During closing argument, the state...
Did any of them see the firearm?
No one saw a firearm. They saw people reaching for a firearm and talking about firearms, but no one saw a firearm. That's correct, Your Honor.
More of a subjective belief.
Well, it's always a subjective belief. The question is whether it's reasonable. Both groups it's undisputed that both groups were in a verbal altercation, that the other group of individuals was approaching Mr. Batista's group, and that they were reaching for their waistbands and acting like they had a firearm. So I'd suggest that this is not a weak claim of self-defense, that this is a viable claim of self-defense. The Florida Supreme Court in Martinez chose not to find fundamental error when the instruction was provided because self-defense was not the only defense, and in fact, it wasn't even the primary defense. This case is more like slosh, which this court found to be ineffective without even an evidentiary hearing in a 3850 proceeding. They found that the instruction was circular and negated the defendant's sole defense, and that reversal of the defendant's conviction was required. This case is, again, on point with slosh, and again, it's our position that in closing argument, the state focused the jury on this instruction by pointing out, the prosecutor argued, everybody there, according to the jury instructions, because now Ronnie Batista is committing, quote, the aggravated assault, had a right to shoot him in the face. Whether the other people had a right to shoot anybody wasn't before the jury. Wasn't a question for the jury. The inescapable conclusion is that talking about Ronnie Batista committing an aggravated assault focused the jury on this forcible felony exception instruction and exacerbated the prejudice to Mr. Batista. For those reasons, we think the trial counsel's conduct was deficient. It's clear from the face of the record. It's also clear from the face of the record that Mr. Batista was prejudiced, and we'd ask the court to reverse on that basis as well, and I'd reserve the rest of my time for rebuttal.
Thank you. When you do come back up, if you could, I want you to address how the witness identification issue, the second issue, is anything but harmless.
Okay.
May it please the court, my name is Lori Hagan. I represent the Attorney General's Office for the state in this appeal. I would first like to dispute the appellant's assertion that his claim of self-defense was corroborated. Even his own defense witnesses said that the situation had cooled down, all the parties had turned around and were heading back to their cars when the appellant all of a sudden broke free, ran up to a car, pulled the gun out of the trunk, ran back. And the defense witnesses said at that point their backs were turned and they didn't see him fire the shot. But three witnesses that had nothing to do with any of the parties saw him fire a shot, said that the victim's hands were outstretched in front of him when that happened, and there was no gun. The only testimony that perhaps the other parties acted like they had a gun was from the defense witnesses said that before the altercation had cooled down, there was some fidgeting and reaching for pants. Maybe there was some concern that there was a gun, but that was well before they had all walked away and the defendant decided to re-engage.
Counsel, can you address, do you think the trial court made the right decision in excluding part of the statements?
No, I don't. I think that the trial court said he did not like what the police had done, but he found that the actions of the police were passive. He specifically said, I find that the actions are passive here because they didn't monitor the conversation. Well, they listened to one of them. They did not participate in the conversations at all. They didn't suggest any questions. They did not recruit the informant. The informant came to them. The court cited all of those factors and found it passive. I'm not sure why they decided then to exclude the evidence about the pending charges, because under the U.S. Supreme Court's case in Moulton, that would not follow. However, they did, and therefore, I think there was no Sixth Amendment violation with regard to either case or either charge, because the law enforcement's involvement was passive. So,
do you think even though they did instruct him to continue the conversation, they did set up this recording device? They said, "Please try to get him to talk about it." Do you think that still qualifies as passive?
Well, I think a number of cases that we both cited in our briefs say that as long as they're not directing the questioning, and they said, go ahead and talk to him. We're interested in hearing about the murder for hire charges, mainly because they also said they wanted to find out who these witnesses were that he wanted to eliminate. but they did not coach him at all. And I mean, there are multiple cases that say that just putting a recording device on and saying, go ahead and talk is all right. And it might offend the conscience somewhat, as it did with the trial court, but it's not a Sixth Amendment violation under the U.S. Supreme Court precedent. With regard to the forcible felony exception instruction here, defense counsel did actually request it, agreed with it, didn't object. However, the state did not comment on this in closing. If you look at there's one sentence that mentions anybody, was everybody committing aggravated assault here? They weren't referring to the forcible felony exception there. If you read it in context, the state was talking about the fact that the altercation had ended and the defendant himself decided to re-engage. And he had claimed, or the instructions claimed, that he was entitled to self-defense because I suppose the victim or somebody else was threatening aggravated assault. So I think that was what that comment was in closing. There was no mention anywhere that the defendant was prevented from claiming self-defense because he was engaged in a felony himself. Nobody argued that. And I think that the claim was so weak that I don't think there's any way the defendant here could show that he was prejudiced by counsel's actions, even though counsel, erred in agreeing to this instruction.
Do you think there's any tactical reason that could be thought of?
There is a tactical reason. It would not look favorably on defense counsel. I mean, if you, numerous cases have mentioned policy considerations of allowing a defense counsel to sit silent and then say, gotcha, if he doesn't get the verdict he likes later. I'm not suggesting that necessarily happened here. It very well could be that he just didn't realize it, but it is something to consider, according to the case law. Does this court have any further questions about any of the issues?
Any questions, Jim? Thank
Thank
you very
you.
much.
Thank you.
All right, Mr. Pennell, just under 5 minutes.
May it please the court. Initially, it's our position that the denial of the motion to suppress on the identification was not harmless because at the beginning of the case, the identity of the shooter was in question. Two of the state's witnesses were unable to pick Mr. Batista out of a photo lineup and were only able to do so, or only able to identify him after the suggestive procedures occurred. So it's our position that identity would have been an issue had the court suppressed the identifications made by the two state witnesses, who I believe were the witnesses that the state argues were not connected to either party. So I think that those are the two important witnesses on the ID, and it would have made a difference had they been unable to identify Mr. Batista as the shooter in this case.
How many other witnesses identified him?
I don't know the answer to that. There's a couple other from the other group that identified him. So certainly there's other
He identified
testimony.
himself as well. Are you saying he would not have testified in that manner had these two witnesses not been permitted to testify?
Well, Judge, you never know. I mean, obviously, as a trial lawyer, your strategy is affected by pretrial rulings. So you don't know. The defendant makes a decision to testify based on in part based on how the trial went. So if the testimony of the individuals that identified him as the shooter was not strong or was substantially impeached, he may have chosen not to testify. So the answer is we don't know because the judge made the error. Additionally, the state's argument that it was only the defense witnesses that corroborated the claim of self-defense is incorrect. Xavier Goitia was called by the state, and he corroborated the self-defense claim on page 471. The argument that the state just told Darnell Adams to talk to the defendant and didn't really give him any guidance, I mean, it defies logic. He came to them with the idea that he was looking to hire a hitman. the police knew what he was going to ask about, knew he was trying to get a deal. He wasn't going to go ask him about the weather. He was going to try to get incriminating evidence against him. So they deliberately
He
used.
was doing that on his own, wasn't he? I mean, this wasn't, as the Molman case said, there wasn't a stratagem developed by law enforcement to elicit incriminating statements. They just sent them in. And again, like Molman said, the statements were more a product of his penchant for loose talk than anything that law enforcement designed.
Well, no, but I disagree with it, Your Honor. I think the law enforcement officer devised a pretty extensive plan here. They told him to talk to him, and then they set up this recording system, which allowed them to monitor and record the conversations. And they did that with full knowledge that Darnell Adams was trying to get a deal and avoid a sentence to where he could get up to 25 years in prison. So they certainly had full knowledge and took advantage of the situation. So I disagree. I think they did design a stratagem to, I don't know how to say that word, but to take advantage of the situation and to knowingly violate Mr. Batista's Sixth Amendment rights as regards to the pending charges. They knew, the detective testified at the hearing, he knew he had a lawyer. He knew now that they were going to talk and listen to his conversations without the benefit of the lawyer. The lawyer is supposed to be the middleman between the government.
But the difference is, in the Moulton Supreme Court case, they knew that they would be talking about the pending charges where the Sixth Amendment attests. In this case, they were going to talk about something that where no charges were pending. Isn't there a difference there? They didn't send him in knowing they were going to talk about the murder charge.
What Moulton says is that you have the right to investigate the additional crimes, but you can't use it against the defendant in the pending charge. And that's what Saunders says based on Moulton. And that's what the judge got wrong, the wrong remedy. The judge found a Sixth Amendment violation, but then imposed the wrong remedy under Moulton and Saunders and all the U.S. Supreme Court case law. It's clear that uncharged conduct could be, statements regarding uncharged conduct could be admissible in another crime under the Sixth Amendment, but not in this case. That's a clear, bright-line rule that's established by the U.S. Supreme Court, and the rule that the trial court failed to apply in this case. And for that reason, and all four reasons cited in the brief, we'd ask for the court to reverse the conviction and sentence. Thank you.
Thank you.